Good morning and welcome to everyone who has joined the webinar on e-cigarettes. We're just giving people a bit of time to join the session before we begin. So just giving it a couple of minutes, just because we started a minute late, and then we'll crack on. Just give it about two minutes, and then we'll start the session. Thanks for your patience. Okay, brilliant. I mean, we're still waiting for a few people to join the call, but this is just an intro, so they shouldn't be missing too much anyway. So we'll just crack on. So again, to those who have just joined, good morning and welcome to our webinar on e-cigarettes. I'm joined by two of my colleagues who will introduce themselves now.
Good morning, everyone. My name is James Burnett. I'm a Senior Compliance Executive in the Compliance team here at CAP.
And good morning from me. It's Jo Walker-Davidson. I'm a Copy Advice Executive, also on CAP. Thanks for joining.
Brilliant. Thank you both. So, essentially, the purpose of today's session is to provide a detailed insight into the rules relating specifically to the marketing and advertising of e-cigarettes. And we hope by the end of today's session, you'll feel confident in the following. So firstly, identifying which media e-cigs can be advertised in, understanding what content cannot be used in e-cig ads and why, recognizing prohibited medical claims, understanding how the rules aim to protect children and young people, and finally, knowing how to target ads responsibly. So here's just a general overview of what we'll be covering. Just a bit of housekeeping. This session is going to be recorded and a copy of the recording will be sent to participants after the event. It'll also be posted on our website. If you do have any questions about any of the content in the session, please do pop it in the Q&A box, and there will be a Q&A session at the end, and we'll get through those questions at that time. Okay, I can see someone's got their hand raised. If you just pop whatever query you have in the Q&A, I'll try and get to it. But we've got quite a bit of content to get through this morning. So I'm going to pass on to the first speaker of today, which is James, who will take us through this a little intro to the ASA and CAP.
Thanks, Lade. Welcome, everyone. Thank you for joining. I really hope you're all well today. I'll just quickly, as I said, cover broadly how the ASA and CAP work before we get onto the specifics with the rules regarding e-cigarettes. I have control of the slides now. Fantastic. Okay, so the ASA and CAP, we are two bodies with shared goals. We work together. The ASA responds to concerns and complaints from consumers and businesses and takes action to ban ads which are misleading, harmful, offensive, or irresponsible. The ASA administers and enforces the rules laid out in the codes, and the ASA is primarily public-facing. CAP, as it says here, also helps to enforce the rules. The compliance team that I'm a part of carries out this function, for example, with enforcement work, such as the recent enforcement notice on vape ads in social media. And we do this through drawing on sanctions that are available to us that we apply to advertisers who can't or won't comply with the rules. The CAP regulatory policy team writes the codes, interpreting the law and undertaking consultations at times to ensure that the rules are appropriate. And the copy advice team offers to the industry advice on pre-publication advertising, as well as writing guidance on our website on numerous subjects. These explain how ASA precedents from ASA rulings can be used to help ensure that ads are in line with the code going ahead. Self-regulation and co-regulation. So For non-broadcast advertising, which is the main relevant area we are talking about today concerning vape products, the ASA operates a self-regulatory system. This means that the ad industry has voluntarily established itself and pays for its own regulation. Broadcast advertising is on a co-regulatory basis with Ofcom, but e-cig advertising is prohibited by law in broadcast media, so it's not of particular relevance here. This is more of just information for background. And I will cover all the media prohibitions that apply to e-cigs shortly. The overall system is driven by a sense of corporate social responsibility in the ad industry. The ASA is non-statutory, which means that our decisions, including with reference to electronic cigarettes, reflect the law as best they can, but they may only go as far as the law. We cannot, for example, make decisions that might exceed the legal position. ASA decisions can be subjected to judicial review, ultimately going to a court required, where they are sort of enforced legally, but generally we are a non-statutory body. The system works because it helps maintain consumer confidence in advertising, which is good for business. It maintains a level playing field amongst businesses, and it's much more cost effective for advertisers than paying for the costs of a court case. And just a note on the ASA Council, quite similar to a legal system, this is the jury that decides whether ads have broken the rules. This ensures that our decisions are of good quality and they are robust, and that the ads being ruled on have been fully scrutinized and the right issues considered in the right way. The compliance team that I work in draws its authority from council. We apply the precedents set by the ASA to ads, which we can establish are clear breaches and don't need to be reinvestigated. 2/3 of the council, which is made up of 13 people, are independent of the ad industry, and the remaining members have recent or current knowledge of the advertising or media sectors. Members are appointed through an open recruitment process with all positions advertised publicly. Collectively, the members offer a wide range of skills and experiences, representing the perspectives of a wide cross-section of society, including young people, families, charities, and consumer groups. There is a page on the ASA website with profiles of the members of council for anyone who would like to read about them. Okay, let's have a look at the scope of the codes with regard to e-cigs. The rules in the electronic cigarette section of the code apply to ads that are for e-cigs or ads that refer to them in some way. For our definitions, e-cigarettes, or vapes, as we sometimes call them, include not just the products intended for inhaling themselves, but the individual components of that device. So as well as all-in-one devices, this would include cartridges, tanks, e-liquids, and so on. They also apply to e-shisha and e-hookah devices, and the rules apply regardless of whether a product contains nicotine. As the sector is relatively new, novel products are sometimes still being developed, and the e-cig rules apply to new products that are sufficiently similar to e-cigs to be reasonably covered. We'll refer to these products and their components as e-cigs generally for the purpose of this presentation. The rule relating to media bans, as will be covered in just a moment in more detail, applies specifically to unlicensed nicotine-containing products and the components. Unlicensed in this case refers to products which are not licensed as medicines. It still includes all of the component parts. This is just to clarify that were a device to be developed and licensed as a medical product, if you can imagine a sort of e-cigarette equivalent of Nicorette gum, it would be a medical product and not subject to this prohibition in the same way. It would, however, be subject to the rest of the code, of course, and the rules that apply to ads for medicines. But generally, we're talking about e-cigs here. Okay, media bans and exceptions. As a lot of you are probably already aware, there are media prohibitions for e-cigarettes. These include most online media, press advertising, and all broadcast advertising, such as TV and radio. Just to be clear, these exclusions do not apply to media targeted exclusively to the trade, and of course, licensed medicines, neither. These prohibitions were not produced by the ASA or CAP. They reflect a legislative ban contained in the tobacco-related products regulations from 2016. So regarding the media ban on nicotine-containing products, it's important to note that the ban applies to non-nicotine-containing products and the components that can be compatible with nicotine-containing products. For example, a vape sold with non-nicotine-containing e-juice, which could be topped up with a nicotine product later on, would be covered by this prohibition. If we were to think about a product that could be advertised in practice, this would mean the only non-nicotine-containing products which would not be covered by the prohibition would be sealed, self-contained disposable products that cannot be topped up with nicotine or used with nicotine cartridge at a later time. So it would be something like an aromatherapy vaporizer, perhaps, that could not function as an e-cig, and that would not be classed as an e-cig product. But with this in mind, it's important to remember that advertising may not have the indirect effect of promoting e-cigs either, which brings us on to this idea of cross-promotion, which I'll cover in the next slide. So staying with the idea of non-e-cig products, there could be examples of ads for such products which breach the rules because they cross-promote e-cigs. This could be done, for example, by using a brand name under which a nicotine-containing e-cig is sold, featuring a regular e-cig product in some way, or content that's otherwise synonymous with an e-cigarette. Or it could be an ad which, when clicked, leads consumers down the way to nicotine-containing e-cigs sort of later on. These are all types of cross-promotion and are covered by the prohibition. This is an approximate list of examples of online media that is prohibited. As you can see, really practically any ad which presents itself electronically to a user is prohibited. These exclusions are intended to reflect the legal prohibition on ads in information society services. This is the legal terminology that's used. This is where ads initiate the interaction with a user, as in social media, for example. Also applies to web online display ads and a huge number of online spaces. In practice, most online ads do fall into this category. A slide a little further on explains the exemption for marketers' own websites. Let's have a look at this case study. This is an example from 2017, but it establishes a valuable precedent. It was a banner ad on the e-cigarette forum planetofthevapes.co.uk, offering a discount on the greyhaze.co.uk website. It linked to a directory page that had a link to the Grey Haze site. The ASA challenged whether the ad promoted e-cigarettes in an online banner ad, a medium in which unlicensed nicotine-containing e-cigarettes and the components were prohibited and therefore breached the code. Grey Haze Online said that the 10% off everything offer was a generic discount code offered to readers of Planet of the Vapes and was not a store-wide discount viewable to the general public. They said that while some of their products, such as e-cigarette kits and pipes, could be used with nicotine-containing e-liquids, those products were not exclusively designed to do so. Planet of the Vapes said that the ad did not directly link to a web page or another website, but to a directory, which was not a paid-for listing, and which did not mention any specific e-cigarettes or e-liquids. They said that the offer 10% off everything was a generic rather than specific product promotion. Therefore, they believed it did not directly promote unlicensed nicotine-containing e-cigarettes or e-liquids, but merely advertised the existence of a vendor which they considered complied with the code. The complaint was, or the decision in the investigation was upheld. In the assessment, the ASA acknowledged that the focus of the ad was on the Grey Haze e-cigarette website rather than any specific product, with no images of specific e-cigarettes or e-liquids. However, it understood the headline claim 10% off everything applied to a number of unlicensed nicotine-containing e-liquids and e-cigarettes, which could be used to consume nicotine-containing e-liquids. The ASA therefore considered that the ad had the effect of promoting unlicensed nicotine-containing e-cigarettes and e-liquids and concluded that it breached the code. So again, remembering that the principle that wherever an interaction with a consumer is initiated by the ad itself in an electronic space, this is forbidden. The ad here was for e-cigs that was served on a web forum about e-cigs, and even though the web forum was in that topic area, it was established the ads in that space are prohibited. Permitted media types. Given the specific media bans, the list of permitted media types for non-medically licensed nicotine-containing e-cigs is fairly short. The key types of common media allowed are outdoor and transport posters, cinema, and leaflets. Other types of media are much more specific, being those directly mailed, private correspondence with consumers, and media that are exclusively targeted towards the trade. One addition to this is retailers' own websites, which may be able to carry some marketing for e-cigarettes in some context. This is covered in more depth in the next couple of slides. The law does apply comprehensive restrictions online. However, CAP understands that the provision of factual information by retailers on their own websites is not prohibited by the law because the consumer has specifically had to seek out that information by visiting the website. Therefore, the interaction with the ad does not originate from the ad itself, but is the consumer pursuing the information. Nonetheless, information provided in this context must only be factual and not promotional in nature. The ASA makes careful assessments of individual complaints based on the content and context of the material in question. CAP considers that, in principle, there is likely to be scope for this position to apply to some social media activity. However, there is no clarity in law as to how this might be achieved. Marketers wishing to try this approach in a low-risk way should try to ensure that the experience with social media is, as far as possible, analogous to that of a website. For example, the privacy or discovery settings of a social media account are set so that claims about unlicensed nicotine-containing products appear only on that page or on that account. They are not shared to users' feeds by an algorithm and are factual in nature. This is why the enforcement notice that was published recently is asking for accounts to be administered to be private, effectively. This is a CAP interpretation of the law. As I mentioned at the start, we can only go right up into the law. We would not apply rulings that go beyond it. If the law is changed or clarified, this would be subject to change. Okay. Here's another case study from 2019. This is on Vape's own Instagram page. The ad featured Lily Allen at the time of the Brit Awards. 2 complaints came in from anti-smoking and children's health organizations. With regard to the media ban, the advertiser stated, given the way Instagram worked, users who saw Vape-related content in their feeds did so because they had previously expressed an interest in or sought out information regarding the e-cigarettes category and/or their products. They said the Instagram Explore feed was based on an algorithm driven by the user, and that content shown to them through that function was based on similar content and the user had followed and the posts the user engaged with. The complaints were upheld. The ASA understood that it was possible for posts from a public Instagram account to be distributed beyond those users who had signed up to follow. Firstly, because posts would automatically be distributed to those following the hashtags. Secondly, because it was also possible for posts from a public Instagram account to appear on another user's Instagram Explore page, where content was automatically generated for users to see. Notwithstanding the above, the ASA considered that in any case, the ad contained information which clearly went beyond the provision of factual information and was promotional in nature. So even if it was a permitted medium, this is promotional information, not factual. Featuring a celebrity in this way and depiction and the information. Just for info, the ad was also investigated as to whether it had specific appeal to under 25s, which is prohibited, and this point was not upheld. Okay, another social media case study here. It shows an e-cig being promoted by an influencer, Louis Shaw. In this case, Relax stated that there was no payment to Louis Shaw and that the code given to him was to refer friends both online and offline, so using an affiliate code. The ASA noted that Relax ran an affiliate program and understood that Louis Shaw would have been gifted the product. As an affiliate, Mr. Shaw had a contractual relationship with Relax, and stories posted under that relationship fell within the remit of the CAP code. It considered both parties were jointly responsible for ensuring marketing content for Relax on the account was compliant with the code. The rule stated that except for media targeted exclusively to the trade, marketing communications with direct or indirect effect of promoting nicotine-containing e-cigarettes and their components that were not licensed as medicines were not permitted in newspapers, magazines, and periodicals, or in online media and some other forms of electronic media. It further stated that factual claims about products were permitted on marketers' own websites and in certain circumstances in other non-paid-for space online under the marketer's control. The ASA had previously considered whether Instagram was an online media space where such advertising using factual claims only was permitted, but it had concluded that neither promotional nor factual content was permitted on Instagram. The decision was upheld because the ad had the direct or indirect effect of promoting e-cigarettes, which were not licensed as medicines in a non-permitted media. So the ASA concluded that the ad broke code. A bit of information about factual or promotional claims in permitted media. Here are some examples of the type of content that, all other factors being equal, are more likely to be factual or promotional in nature. However, the lack of clarity in the law and the creative nature of advertising mean that CAP cannot provide comprehensive and definitive lists of what falls into each category. In relation to pricing and promotions, advertisers should take particular care. In practice, marketers may price their products in groups of their products as they see fit, and different bulk prices and reduced prices may be acceptable. However, care should be taken that those prices or pricing structures are not communicated in a promotional way. Product names and flavors should also be used with caution, as those are promotional in nature and/or include product claims that would be unacceptable. These names should remain factual and objective. Where permitted, factual claims made on marketers' own websites or elsewhere, they must continue to comply with all relevant CAP content rules. And finally, for me, an exception to the ban on broadcast advertising, in case it is of relevance to anyone in this session. The rule prohibiting broadcast ads is not intended to prohibit the promotion of electronic cigarettes as a means of smoking cessation as a part of a public health campaign by a national government department or national health bodies or stop smoking services or charities that do not receive any funding from the tobacco or electronic cigarette industries. But such campaigns must not be conducted in the course of a business or seek to promote specific unlicensed nicotine-containing electronic cigarette products. That's that. And I think I'm handing over to Jo.
Yes, lovely. That's brilliant. Thanks so much, James.
Thank you.
And now we've sort of had a look at the prohibitions that apply to the content. Let's look at the rules that relate to the content in media which aren't subject to the prohibition. So, the content of e-cig ads is quite tightly regulated, especially in relation to links to tobacco products. There are some rules relating to, excuse me, I've got a tickly throat today. There are some rules relating to non-smokers and medicinal claims, and as you might expect with ads for age-restricted products, there are also rules limiting appeal to children and specific targeting and scheduling requirements. So let's have a look at these in a bit more detail. First off, tobacco links. And because e-cigs have much in common with tobacco cigarettes, care must be taken not to implicitly promote tobacco products and therefore undermine the prohibition on the promotion of those types of products. Nothing in the ad should promote the use of a tobacco product or show it in a positive light. Imagery, design, and logo style are all areas in which an association could implicitly be made in an audience's mind. And one of the primary applications of the rule is to prevent tobacco companies using e-cigarettes to promote tobacco products. So by using shared branding. So for instance, an e-cigarette carrying a Silk Cut branding or Lucky Strike would be so clearly associated with a tobacco product that it would just have the effect of promoting one. Products that are simply cigarette-like, for instance, white with a beige filter tip style, may be shown without breaching the code, although it must always be clear that the product is an e-cigarette. And this can ordinarily be achieved through clear ad copy and product descriptions and the like, and references to e-liquid. And we've got an example here to have a look at. And I should just note that this is a press ad, and the ruling predates the ban on ads for unlicensed e-cigarettes in this particular media, but I think it's helpful as an illustration. In this case, the ASA noted that the image of the product had the appearance of cigarettes in cigarette packaging, and that the font of the e-lights text and the emblem above, along with the red and white colouring, were reminiscent of a well-known tobacco brand, which we might all be able to recognise there. However, because the ad featured the text, the UK's most popular electronic cigarette, and very clearly branded e-lights rather than the cigarette brand, the ASA considered it made sufficiently clear that the product was an e-cigarette and not a tobacco product, and as such, complaints against the ad were not upheld. Thinking about non-smokers, although public health officials have stated that e-cigs are safer than smoking, they're still an addictive and potentially risky product, and as such, ads must not encourage non-smokers or non-nicotine users to take up e-cigarettes. While ads do not always need to state that e-cigs are an alternative to cigarettes, they should not imply that they're suitable for people who don't currently smoke or do not otherwise use nicotine. And you should take care when developing claims encouraging people to try your products, that they don't imply that everyone should try them regardless of their smoking status. And you can hopefully see a snippet here from an ad which said, "I used to smoke normal cigarettes, but after I quit, I tried these." Now, in its assessment of the ad, the ASA felt consumers were likely to understand that the person who spoke the line has stopped smoking for a period of time and was therefore a non-smoker who's subsequently taken up using those e-cigarettes. And the ASA considered really that this statement encouraged non-smokers to take up using e-cigarettes, and concluded that the ad was irresponsible on that basis. And on the topic of people who've given up smoking, smoking cessation claims or quit claims are medicinal claims, and when made for a specific product, can only be made for products which are licensed by the MHRA, who are the medicines regulator. Ads can encourage people to switch for a variety of reasons, for instance, the smell or the cost, but may not state or imply that switching to e-cigs will help consumers quit smoking. E-cigs may be presented as an alternative to tobacco, but advertisers must do nothing to undermine the message that quitting tobacco is always the best option for health. Broader claims relating to e-cigs in general may be able to reference smoking cessation when they're not product specific. For instance, if you're trying to quit smoking, you might benefit from switching to e-cigs. But ads using these claims can't imply that these general claims will apply to a specific product. And really, in practice, such claims are unlikely to be acceptable when made by an e-cigarette company or a retailer, because that would imply that the specific products that the company made could carry a smoking cessation claim. And as such, those sorts of messages are generally more likely to be found in public health messaging. Where e-cigarettes are licensed as medicines and can therefore bear smoking cessation claims, you've still got to note that ads for such products are still going to be covered by the code, including the medicines section of the code. And regardless of having a license, ads are not able to use health professionals to endorse e-cigarettes. And the only exception to this is the public health campaigns allowed for in broadcast advertising. And we've got an example to look at here. So it's kind of a sip of juice. Now, here's a press ad, and again, it's predating the media ban, which made reference to Stoptober in the promo code, which you can hopefully see highlighted at the bottom of the screen. The ASA was concerned that as the ads use words like Stoptober, consumers were likely to understand that the product was associated with or endorsed by the NHS campaign Stoptober, which they understood was not the case, and they were therefore likely to believe that the product was suitable for use as a smoking cessation device. The ASA noted that most of the ad's content focused on the quality of the product, but because they considered the ad implied that consumers could use the product for smoking cessation and the product wasn't licensed, they concluded that the ad breached the code in that regard. And a quick note on nicotine content, which is where nicotine containing products are advertised, where they're allowed to be advertised, the fact that they contain nicotine should be stated. This is a specific rule in the CAP code, that's a non-broadcast code, but it's removed from the BCAP code because the only nicotine containing e-cig ads that can be marketed in that media are licensed medicines, and the nicotine content is required to be specified anyway as part of the product specifications for the product license. And as well as the e-cigarette rules, all content must still comply with any other relevant parts of the CAP code. And it's quite easy to focus on just the e-cigarette rules, but there are standards that apply to all advertising, and that's always something that's important to bear in mind. This includes the fact that ads must not mislead, cause harm or offence, and they must be socially responsible. And as touched upon before, the medicine section of the code will apply if that's relevant to the product being advertised. And for instance, there's a section on the code that's related to environmental claims, and that's going to apply if that's something that you're thinking of making environmental claims about your products. I just wanted to have a quick look at the environmental section of the code. Now, Rule 11.1 for the non-broadcast and 9.2 for BCAP states that the basis of environmental claims must be clear, and unqualified claims could mislead if they omit significant information. So it's just really important to consider that if an ad makes a claim about a product's environmental credentials, is it clear what the claim is based on, and are consumers given enough information or context to understand what the overall claim refers to? And this is separate from the question of whether the advertiser has enough evidence to back up the claims that they're trying to make in their ad. And the rule really just requires that the ad itself just gives consumers enough information to understand what kind of claim is being made and what that claim is based on. And in the absence of any qualification within an ad, a very, very broad statement such as the product is simply environmentally friendly is likely to be regarded as a very absolute claim that the product is unequivocally friendly to the environment, which may ultimately be difficult, if not impossible, to substantiate for most products. And we do have an example to look at here. So this is a digital billboard which included the statement recycling for a greener future. And in this case, concerns were raised that included whether the ad misled about the environmental benefits offered by the product, and did not make clear that there were in fact limited recycling options available. The ASA considered that a relatively small proportion of customers who saw the ad would know that single-use vapes could be recycled or be aware of the appropriate routes to use. And they noted that single-use and rechargeable vapes were classified as electrical equipment, and as such couldn't be recycled, for instance, by your home recycling or other easily accessible routes. The advertiser stated that the general intention of the ads was to raise awareness that their vapes could be recycled, and to encourage consumers to engage with recycling, and that the Green Awareness Programme was intended to cover this, and the ASA did acknowledge that. However, because in the absence of additional qualification, consumers were likely to understand from the ad that they would be able to recycle elf bars, single-use vapes through a wide variety of routes, when that was not the case, and the ASA concluded that the ads were misleading on that basis. And for some of the reasons already noted, the ASA considered that the ad implied that the vapes were completely recyclable, and in the absence of additional qualification, they considered that the claim for a greener future was ambiguous and was likely to be understood by a lot of consumers as a claim that elf bars recyclable vapes had less environmental impact than other vape products on the market. And because they hadn't seen evidence to demonstrate that this was the case, they concluded that the claim for a greener future was likely to mislead consumers just because it didn't have that extra qualification in there to explain the basis of the claims. And now then, going to look at children and young people, which is, well, I was going to say it's a hot topic at the moment, but it always is with age restricted products, I think. So as e-cigs are age restricted products, with especially high risk to the young, there are strict rules governing appeal to under 18s. Ads must not be likely to appeal particularly to people under 18, especially by reflecting or being associated with youth culture. They should not feature or portray real or fictitious characters who are likely to appeal to under 18s or show people behaving in an adolescent or childlike fashion. And particular appeal means content that will apply to under 18s more than it would to adults, rather than something that appeals to both groups generally. So some content, such as comic book imagery or cartoons, may tread quite a fine line. And we've got an example to look at here. So here we have another digital billboard ad, and there were two other ads in a similar style that featured Santa and an elf in a similar sort of style. And complainants challenged whether the ads were likely to have particular appeal to under 18s, and therefore that they were irresponsible. The advertiser did say that the ads had been purposely designed to bear no resemblance to traditional seasonal imagery, which might be particularly popular with children. And their intention had only been to appeal to the spirit and culture of a target audience of adults, and they felt it was a bit off the wall and adults would get that. They also said that the characters depicted in the campaign actually were almost sinister in appearance, which kind of reinforced their own opinion that the ads would only appeal to adults. However, the ASA, while they acknowledged that the advertiser didn't intend for the ads to appeal to under 18s, they felt that the use of this sort of cartoon-like imagery, which they felt was childlike rather than adult-like, had the potential to appeal to under 18s, and complaints were upheld on that basis. Now, I don't think that necessarily precludes advertisers from mentioning Christmas, or indeed maybe even using gingerbread men, but I hope this example illustrates how ads can sometimes be on the wrong side of the line. Again, more widely, under 25s, as part of the stringent protections for under 18s, ads mustn't feature under 25s using e-cigarettes or otherwise having a significant role. And the reason for the minimum age being set higher than legal purchasing age is because young adults may be viewed as aspirational figures by 16 to 17-year-olds, and that might therefore potentially encourage younger people to emulate people they look up to. And the wider buffer balances the need really to protect under 18s against the ability for advertisers to use a wide variety of themes and images for their ads. And you can see a couple of examples here. These are tweets, and both the medicines regulator and the ASA challenged whether the ads show people who seemed to be under 25 years of age using e-cigarettes. Now, while the people depicted in the ads were all adults in their mid-20s, the advertiser acknowledged that the lighting and makeup used could maybe affect their perceived age and withdrew the ads. And indeed, the code stipulates that people shown using e-cigs or playing a significant role must neither be or seem to be under the age of 25. So even if someone, like myself, they're over 25, but they might very much look under 25. So that's always going to potentially be a problem in an e-cigarette ad. And in this case, the ASA concluded that the ads were problematic because they featured people who seem to be, could be under the age of 25. Now, in terms of significant role, if you're considering using under 25s in ads, advertisers have got to take a great deal of care to ensure that they only appear incidentally and not, as mentioned, playing a significant role. But what does significant mean? Well, something incidental might include a minor part of a larger mixed age group, like being at a family dinner, or part of the background of a shot that focuses on older adults. And significant is likely to include, but isn't limited to, speaking parts or otherwise being the main focus of a particular scene. And then just a final section on targeting and scheduling. And as well as content rules, there are placement restrictions for e-cig ads as well when they're appearing in permitted media. The general principle is that targeted marketing should not be directed at under 18s, and that broader marketing should not appear in places where more than 25% of the audience is under 18. Depending on the media, the way that this is achieved is going to vary. Some media, such as outdoor display, is very broadly targeted and should therefore be kept away from schools, where foot traffic is more likely to include a high proportion of under 18s. And really the aim is not to completely prevent under 18s from seeing e-cig ads, but just to appropriately limit their exposure while reaching a valid adult audience. And the content rules mean that where under 18s do see e-cigarette ads, that the content should still not appeal to them and don't contain anything that's likely to be harmful to them. And just in line with sort of the earlier explanation on the media bans, just remind that certain media types may only be used for non-nicotine containing e-cigarettes or for nicotine containing e-cigs, like licensed medicines. For non-broadcast ads, there are different standards according to the media used for placement. As noted, some media like outdoor displays very broadly targeted and should be kept away from schools. Flyers shouldn't be given or sent to under 18s, or circulars and the like. And for online ads with respect to medicinal or non-nicotine containing e-cigs, targeting can be much more detailed, and there are several requirements on advertisers looking to use this media type. And it's quite a large topic in its own right, and we've got some detailed guidance about that available online if those are the sorts of products you're advertising. I've just got a quick case study here. And this is an ad seen on a bus shelter poster, and concerns were raised that it was inappropriately targeted because school children were known to use that bus stop. The ASA understood that the stop was in a residential area and was not used exclusively by school children, and the data provided showed that there was a significant distance between the ad and the closest school. And while the ASA acknowledged that children using the bus shelter may have seen the ads, they considered it unlikely that people under 18 comprised more than 25% of the audience, and therefore they concluded that the placement of this particular ad did not breach the code. And as you note there, the content is there's no appeal to children, and while some children may have seen it, it wasn't directed specifically at them, so the ad wasn't upheld. And then finally, quick note on scheduling. And as James had mentioned earlier, e-cigs ads are banned from broadcast media, but however, those that are licensed medicines and general public health campaigns are able to be advertised on TV and radio. And in those cases, the ASA consider BARB data, which is used to generate an audience index to work out the likelihood of under 18s watching a particular programme, and such ads should be scheduled away from them. And that is the end of our speaking, but maybe not the end of our speaking to you. If you've got any questions, it looks like we have a few.
Yes, if you do have any questions, please do pop them in the Q&A. There's quite a few people on this call, so we'll obviously try and get through as many as possible, but any questions that we can't get to, I'll give you the link to our copy advice team who can offer free advice. But we'll start by going through. Someone did ask, what about outdoor advertising? I think this is in relation to restricted media.
Yes, yes, and thanks for that question, Russell. And I think James did go on to note that outdoor is not actually a prohibited media. So I hope that presentation answered that question for you, Russell.
Brilliant, thanks. Someone asked, how does this affect trade publications such as Vape Around? Can we continue to advertise as normal through those means?
Yes. Oh, sorry, James, go.
No, I mean, yeah, that is effectively a permitted medium. If a publication is circulated exclusively to the trade, then that wouldn't be prohibited. But if a publication, I think the ASA has ruled against, it was actually a tobacco product, it was cigarettes, in a sort of staff magazine that was said to be a trade-only publication, but the ASA ruled that it was actually effectively advertising to the public because it was circulated so widely to the staff of a national retailer that it was effectively falling into public hands. So yeah, with caution, trade publications are permitted, but they really must be to the trade, not distributed to regular people.
Great.
Thank you.
And then we also have a question, how does this affect promotional items in stores, vape stores? Can we continue as we do now? So yeah, the actual factual versus promotional content is more to do with the exceptions that are allowed in online media. So, for instance, websites could have factional rather than promotional content. Promotional items in store are a little different, aren't they, James?
Yeah, I mean, this would be considered point of sale material, and that is outside the remit of the ASA. So the ASA only covers, apart from online, the ASA only covers paid for advertising space, apart from online. So point of sale in store is okay. It's at least outside of our remit. We would probably advise seeking legal advice on that. There is likely to be regulation that applies to it. Most large companies probably do have the legal counsel that advises them on that. So if you're receiving material to display in store, it probably has been checked in some way, but it's always best to seek legal advice as to what you're displaying. You know, people could complain to their local councils about that kind of material. So it might not be compliant, but it's outside of our remit at least.
Mm. And then question from Jamie regarding smoking cessation claims. And I appreciate your comment that might be, you know, if they are indeed safer or not, that's kind of, it's irrelevant really to the advertising code. And really smoking cessation claims are treated as the medicinal claims, and as such further to the code, because you're making a medicinal claim, you can only make a claim of that nature if the product has a license, because it's as if it was a medicine. So if your product's licensed and subject to, you know, everything else is otherwise acceptable, then in fact you could do, but it's just the nature of the claim rather than whether or not it's self-evident that vaping can assist with cessation, if that makes sense. That makes sense. What I said to you, James, sorry.
Yeah, I mean, you know, medical products are tested and are held to quite tight regulations. I mean, thinking hypothetically, if there was a broad allowance of any product out there to make a medicinal claim, there could be some sort of issue where there could be a filter or other component that's used that releases a harmful substance. You know, things like materials such as asbestos have been used in filters before, and we all know now that asbestos is extremely harmful. So if that could be the case, then it could be the case that any product out there that's a vape could make a medicinal claim. And for reasons like that, that's why only registered devices that are licensed and have been tested and gone through rigorous screening are able to make such medicinal claims.
Yeah, and that's across all product categories. Only medicinal claim in any field, you can only make it if it's for a licensed product as well. So it's not specific to e-cigarettes. It's just the medicinal rules about medicines, basically.
There's a sort of follow-on question this from Ryan. Thank you. When discussing e-cigarettes for cessation, you have some contact with stop smoking services in your area, and you're asking how can you collaborate with stop smoking services and talk to members of those services. Well, in material that's leaflets and so on, it wouldn't be possible to make any claims about stop smoking services with your products. I mean, in-person communication is outside of our remit, and I mean, you know, live communication or consultations with people is not something we cover. Again, we're not advising this is necessarily legally sound. There could be other regulations in place that would require you not to say certain things, but in-person communications would be permitted as far as the advertising code is concerned. Is there anything else you can think of, Joe, in that area?
No, I think that's basically covered it, and that's
Yeah.
Communications of those stop smoking services is different to advertising smoking cessation claims for your own product as well. So I think that's kind of two different sides of the coin there as well. Where have we got? Sorry, scrolling down these questions.
So the next one would be, would products such as nicotine pouches and heated tobacco devices, where promoting the device only, come under the same rules as tobacco and e-cigarettes, or are they subject to different regulations?
They would be. The heated tobacco products would be covered by the tobacco rules, which are in a different section but the regulations are quite similar. Nicotine pouches, obviously these are sort of novel products. We've still investigated the rule against these as socially irresponsible. But they don't fall within the e-cigs rules at the moment. But given that they are controlled products and age-restricted products, they are attached to the social responsibility rules as of now, and are regulated by their own sort of area.
Yeah, that's a current state of play. And then another one from Jamie. Does in non-paid for posts and non-private accounts refer to current existing Facebook page? Sorry. Okay. If so, if we were to create a private Facebook group where requests to join have to be approved, we'll be able to post more freely in this group. I think in theory, it's just really got to be, as James was saying earlier, only content that's discoverable by people who've actively sought it out. So if they've actively sought to join your group, and that's the only people that you're communicating with, there's some leeway there. But remember, the content should still only be factual rather than promotional. So important point to remember.
Yeah, if it's analogous to a website, the ASA recently did consider that a private Discord server could be a permitted medium on similar grounds that you're stating, Jamie. As I said earlier, if the law changes, where even if someone has subscribed to be in a group, but they get served something that they could be engaging with some other content and they get served something, that law could change, that it says no, this is not analogous to a website. CAP's current interpretation is that we're giving leeway to allow private social media like this to be analogous to a website. This is subject to change, but that's where we're going at the moment. Yeah.
And then the question on pricing. My understanding is that we can post images of products, for example, e-liquids, but cannot mention pricing or deals such as 3 for £10. I think that's slightly incorrect. We'd consider generally statements of price is factual information. Your product costs £2 or £3 or whatever. Where it becomes promotional is, for instance, I don't know, was £5, now £2. It's taking a statement of price, simply saying your product costs X, and then applying something that goes beyond just providing factual information, so making the prices more attractive or slash-throughs or that sort of thing. So in theory, I think saying one cigarette will cost you £3, 3 will cost you £10, it feels factual in nature to me rather than promotional.
Yeah, that's right. Those kind of bulk prices that are stable are okay. I think if you were doing a temporary price, that would be promotional. That becomes a promotion then, when it's a sort of temporary deal where there's kind of pressure to buy within a certain time limit. That's would not be okay. And as Joe said, any price that sort of slashed through, where it was this price but now it's less, that would be promotional too, not be okay. But if a general bulk price that always is in place, it's a permanent price, is okay. But these need to be objectively presented.
Yes.
I believe that we've answered the question about private social media accounts. So I'll move on to another. Would promoting an age-verified e-cig loyalty platform with online ads come under indirect promotion? And secondly, would marketing to people on the age-gated platform be permitted, given they're age-verified and have opted into communications? Would you like me to repeat that?
No, it's okay. I could see that then, Abby. Thank you. Well, I think in theory, if we're thinking about an ad which talks about e-cigarettes and promotes them, even if it's not necessarily selling them, then I think we might have to consider whether or not that is indirectly promoting e-cigarette ads. And then it's about, is that factual or promotional, rather than it's targeting people, even if people have signed up to it. and they're welcome to receive information. Is the information they're receiving actually going to be promotional in nature? So I think that's something that would need to be approached with caution. Would you agree, James? I think it's a bit difficult without seeing the ad in the.
Yeah, a query like this, we would advise going to the copy advice team, which I mentioned at the beginning,
Yes.
which is part of CAP, which Joe works in fact, and get a sort of full considered response with some detail. An e-cig loyalty platform online is likely, on the face of it, does sound promotional, and then marketing for people sort of when they're within that system. Online, that's definitely a complicated area. I think it needs some unpacking and some sort of more in-depth discussion about exactly what content is going to be there and how people are going to be incentivized through a loyalty scheme.
Yeah. And then a question from Yusuf: how do the advertising rules affect advertising products in shop fronts that the public can see? Well, in theory, that's kind of point of sale material, so it would be out of the ASA's remit, unless it contained a specific promotion. Whether or not other rules, other laws and regulations apply is something to maybe consider separate legal advice on, but it would fall out of the ASA's remit. Would you agree, James?
Yeah, that's outside our remit. There could be other legal restrictions on it. And your local council may be concerned about material that's posted in your shop front.
Yeah.
Is there a date in which social media pages must be turned private?
As soon as possible, but the deadline is next Thursday, according to the enforcement notice that was published a few weeks ago. So after that period, public accounts may well be sanctioned, which means they could be removed.
Thank you. What would the use of emoticons have the potential to be classified as attractive to children when used within social media captions?
I think they would be promotional, so would probably be prohibited on the promotional basis. Do emojis specifically appeal to children? Some might, to be honest. Cartoon type figures. Yeah. I would say possibly some might. Some emojis have probably been around long enough. They don't have specific appeal to children, but I would say they do seem promotional.
Yeah, I think they've certainly got the potential if they're used in the wrong way or with a lot of other noise, etc. I think there's the potential there for them to be problematic. Then we've got Stoptober is a public campaign. Can vape manufacturers advertise and be part of this campaign? And what are the restrictions? It would only be advertised on the webpage or social media of the vape company. Well, as kind of with that example from the presentation, I think there's always a risk that references to Stoptober or participating in Stoptober, when you're a vape manufacturer or retailer of vapes, kind of, I think there's always going to be the risk that there's going to be an inherent link between, oh, well, participate in Stoptober, use our product, and that's going to be at the least potentially seen as suggesting that your product can be used with smoking cessation, and if it's not licensed, then that could really be potentially problematic to do that, I think. Would you agree, James?
Yeah. Stoptober is an implied cessation claim, effectively. It's not going to be okay to be in advertising.
Yeah.
I've got a question here. Someone's just asking for clarity. So they're asking if they were to market via platforms like MailChimp, can this be done because obviously people subscribe to receive them, or is that just not allowed? So marketing emails, someone's getting a marketing email from a vaping brand and they've subscribed to it. Is that okay because they've subscribed to it? Is this just not allowed?
I think this is a prohibited medium. If it's not a sort of private one-on-one communication, this is not permitted online.
Okay.
And then we've got a question from Laura: if the product is registered with the MHRA, is it then classed as a as a medicinal product. Well, in order to, I think, in short, yes, if you've got a license to apply for a license from the MHRA, then they will have granted that license for a particular reason. So, and that's a big process to go through.
There is sort of two levels to it. So I think that's okay. The MHRA has to sort of approve products and have restrictions on products, sort of that a tank can't exceed a certain size. So it approves e-cigs for sale, but that doesn't necessarily mean they have a medical license. If something is a registered medical product, that's a far more restrictive and thorough procedure. So just to clarify between those two levels of something that's permitted by the MHRA to be sold because it follows the general regulations on the power or the size of the container of e-juice. That's one thing, but it doesn't mean it's licensed as a medicine. So just to clarify those two things, not have them confused. There is two different MHRA directives there against products.
Brilliant. Can I just interject, because I see that we're running out of time. There's just two things that I just want to bring on before we have to wrap this up to a close. But someone's come back to us regarding the marketing email. They've basically said they see sending marketing emails as a one-to-one communication that they're sending to people that have subscribed. So they just want us to expand on that. And finally, I can see they've got quite a few questions we received about the restrictions on social media. So I think it'd be really good if we could just wrap up by just explaining explicitly in terms of social media accounts what the enforcement notice says and what restrictions are going to be put in place. And then after that, if anyone does have any other questions, I'm sorry, but we won't have time to go through them. But I will send a follow-up email with a resource to the copy advice team, and you can just send your queries at that way, and someone should get back to you within 24 hours. But on those 2 points, it'd be great to just get some clarification. So going back to the marketing communications that are sent via email, the person that did put that question just wanted clarification, because they were of the understanding that was a one-to-one communication with their customer who has obviously subscribed to receive that, but obviously we've just advised that that's not permitted. So are there any further points that we can add on to that just to help their clarification, and then we'll go on to social media after?
I'm just going to read straight from the ASA website here because this will give the clearest indication. You can find this sort of information by Googling and searching on the ASA website as well. So advertising unlicensed nicotine-containing e-cigarettes in emails or other forms of electronic messaging is prohibited. But we understand that the law may allow marketers to respond to specific requests from consumers for information by email on a one-to-one basis, though marketers are advised to seek legal advice before doing so. So yeah, this does sound like bulk emails are not permitted, but this one-on-one requests is okay. As well as seeking legal advice, marketers are advised to ensure they are able to demonstrate the following. Consumers who receive the message have specifically opted in to receive it. GDPR is observed. Recipients are given the option to opt out with every communication. That information contained such communications is factual and non-promotional. This does sound like a complex legal area, and as it says, seeking legal advice is advised. It looks like this sort of wide-reaching mailings that are general are not permitted, but this kind of one-on-one thing may be permitted. But I imagine the law is extremely complex and vague, which obviously makes it quite difficult for us to write codes to regulate it.
Okay, I hope that helps to provide some clarification. If not, I will send through resources for you to read so you can reference that. Or like I said, further discussions can be taken up with the copy advice team. But I just want to wrap it up with my final point. So we have got a few questions regarding social media. So whether that be social media pages, Facebook business pages, and so forth. So can you please just wrap up this session by just explaining what restrictions are in the enforcement notice regarding social media accounts? So, you know, what can be posted, what can be featured, and all the rest of it. And then we'll have to wrap up the session, unfortunately.
I do advise everyone to read the enforcement notice. It is only 2 pages long. and you can find that on our website and by searching Google as well. Effectively, it requires any medium online that can be served to anyone openly, pushed out by an algorithm, is not permitted. This is restricted. Your social media pages have to be similar to a website, i.e. you type in a account name or URL and people find it that way. There's no sharing, there's no feed that pushes it out to people who have not shown that they're already interested in following that account. Once that account is administered in such a way, generally this will be through making the account private. The information there can only be factual. It's not allowed to have promotional claims. It's not allowed to have sort of music or dynamic graphics or any embellishments or excessive use of people using the products that seems promotional.
Brilliant. Okay. Thank you for that. I appreciate that this is quite a weighty topic and people are going to have further questions come through. Like I said, you'll all receive an email with a list of all the resources that are available. And like I said, a direct link to our copy advice team who will answer any query you have for free within 24 hours, so long as it's submitted on a working day. So obviously, if you submit a query on Friday, you won't get a response till Monday. But I would like to thank every single person for joining the session this morning. And I want to give special thanks to James and Joe for delivering this session. So thank you very much. Like I said, the session's been recorded and I will put a copy of the recording on our website, which you'll also receive a link to. Thank you very much and have a lovely day.
Thanks all.